We got our mystery sorted out. All right. Good morning, everyone. This meeting is called to order. Mr. Trillman, has anyone signed up for public comment? Thank you very much. Good morning, Ms. Miller.
Good morning, sir.
No cases to reconsider under agenda item 3.
Correct, no cases.
Let's look at tax
Gracias.
liability cases under agenda item 4. We have no tax cases on docket 31.
Correct, no cases.
No fair housing cases.
Correct, sir.
Under agenda item 6, we have one wage claim case on docket 31. It's been pulled for additional discussion.
Yes, sir. It's case number 21-058625-3. Commissioner Alvarez?
The WCAT decision is incorrect. The employer sold its business to another entity and the claimant signed an agreement with the employer in this case to continue working for the new company in exchange for $1,500. The employer paid the initial $600 under the agreement, but has refused to pay the remaining $900 as required under the agreement. Texas Labor Code 61.0015 states that employment means any service that is performed for wages or under a contract of hire, whether written or oral, expressed or implied. In this case, the service performed by the claimant was remaining employed with the new company in exchange for $1,500. The claimant has performed as required under the agreement. The claimant is therefore owed wages pursuant to section 61.005 of the Labor Code. Reverse the WCAT, $900 in wages owed.
The AT decision is supportable. The claimant's former employer sold the business. Prior to the sale, the former owner told employees he would pay a retention bonus, but no specifics were given that would have made the general commitment into a legally enforceable wage agreement. After the claimant stopped working for the named employer and began working for another company, she and the owner of her former employer made a verbal agreement that the former owner would pay her a specific retention bonus for staying with the new company for a year. At the time of that agreement, there was no longer an employment relationship between the claimant and the named company. Because of the lack of an employment relationship, the claimant's dispute with her former employer is not within the jurisdiction of the Texas payday law. Any claim that she may have against her former employer would be under the jurisdiction of the civil court system, not the Texas Workforce Commission. Accordingly, we should affirm the AT decision. The claimant is not entitled to a bonus from her former employer.
Affirm the WCAT wage claim dismissed, no wages owed.
Short form dissent.
Yes, sir. Short form dissent. And you should have received the wage claim short form dissent list for docket 31.
I move we accept staff recommendations on the remaining wage claim cases on docket 31.
I second the motion except for those cases on which I'm dissenting as reflected on the wage claim short form dissent list for docket 31.
Concur with the chairman's motion, except the cases on which I'm dissenting as reflected in the wage claim short form dissent list for docket 31.
Motion passes with the exceptions noted.
Thank you.
Thank you. Let's move to agenda item 7, consideration of unemployment insurance cases on docket 31. Please proceed when you're ready.
The first 11 cases will be called together. Case number 298-2095, case number 308-7818, case number 308-7827, case number 308-7839, case number 308-7845, case number 308-7940, case number 308-7973, case number 308-7978, case number 308-7986, case number 308-7991, and case number 308-7996. Commissioner Alvarez.
I maintain my vote in these and related cases that the employer did not timely respond to the agency's notice, and there is no legal rationale to deem them timely. In the alternative, the record was not developed regarding the separation from the relevant employer. The claimants in these cases perform services for multiple separate legal entities operated together. The employer has provided testimony and evidence regarding their separation from the last location they worked prior to the pandemic and not named employer in these cases. The employer in these cases has alleged that the employees were separated due to the pandemic, even though in many cases the employer did not report wages for these claimants during the quarters relevant to the pandemic. It seems to be inappropriate to issue decisions on chargeback in these cases where the relevant separation has not been addressed. Remand with both parties invited. Also, send a memo to tax to determine whether the employer and all employer tax accounts for entities related to this employer are engaging in payroll and possible pseudo dumping, as well as any applicable penalties under section 204.087 of the Labor Code.
The AT decision in each of the 11 companion cases in this group is not supportable. As with similar cases on prior dockets, the employer's protest to the NMPC in each of these companion cases should be considered timely due to the employer's reliance on earlier statements from TWC and other state officials. Regarding the merits of the chargeback issues, the employer's testimony and other evidence in each case indicates that the claimant stopped working for the named company due to quitting with or without notice while continued work was still available at this company's location. The employer's policy is that any employee can work at any company location, which means that they can go from one employer account to another at will. A voluntary resignation for personal reasons qualifies the employer for chargeback protection under section 204.022 of the Act. Accordingly, we should reverse the AT decision on the late protest issue, hold each protest timely, and protect the employer's account from chargeback.
Reverse the AT, timely response to the NMPC, no chargeback.
Short form dissent and memo to text as referenced in my comments.
Yes, sir. We have both of those.
The next 4 cases will be called together. Case number 298-2105, case number 298-2365, case number 306-5981, and case number 308-7786. Commissioner Alvarez.
I maintain my vote in these and related cases that the employer did not timely respond to the agency's notice, and there is no legal rationale to deem them timely. In the alternative, the record was not developed regarding the separation from the relevant employer. The claimants in these cases perform services for multiple separate legal entities operated together. The employer has provided testimony and evidence regarding their separation from their last location they worked prior to the pandemic, and not the named employer in these cases. The employer has alleged the claimants quit. However, in many of these cases, wage records show reported wages for the claimants for one or more entities related to the employer after the separation. These cases should be remanded to properly address the separation. Remand with both parties invited.
The AT decision in each of the 4 companion cases in this group is not supportable. Despite the late protest of the chargeback notice in each case, the employer consistently and credibly testified that the company was misled by what it perceived as assurances from TWC and other state officials that no protest was necessary due to the pandemic. The employer's protest to the NMPC in each of these companion cases should be considered timely. Regarding the merits of the chargeback issue, the employer's testimony and other evidence in each case indicates that the claimant stopped working for the named company due to quitting while continued work was still available. A voluntary resignation for personal reason qualifies the employer for chargeback protection under section 204.022 of the Act. Accordingly, we should reverse the AT decision on the late protest issue, hold each protest timely, and protect the employer's account from chargeback.
Reverse the AT, timely response to the NMPC, no chargeback.
Short form dissent.
We have a short form dissent, Commissioner Alvarez.
The next 2 cases will be called together.
Excuse me, those need to be called separately.
They're called separately. Case number 298-2385, Commissioner Alvarez.
I maintain my vote in this case and related cases that the employer did not timely respond to the agency's notice, and there is no legal rationale to deem the response timely. In the alternative, the record was not developed regarding the separation from the employer. The employer has alleged the claimant quit while on medical leave. However, there are inconsistencies between the wages reported for the claimant and the employer's testimony on the date of the separation. This case should be remanded to properly address the separation. Remand with both parties invited.
The AT decision is not supportable. As with the other companion cases involving the employer's protest to the NMPC should be considered timely. Regarding the merits of the chargeback issue, the employer's testimony and other evidence indicates that the claimant stopped working for the named company due to quitting while on medical leave on June 7, 2019, even though continued work was still available. A voluntary resignation for personal reason again qualifies the employer for chargeback protection under section 204.022 of the Act. Accordingly, we should reverse the AT decision on the late protest issue, hold each protest timely, and protect the employer's account from chargeback.
Reverse AT, timely response to the NMPC, no chargeback.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 308-7727, Commissioner Alvarez.
I maintain my vote in this and related cases that the employer did not timely respond to the agency's notice, and there is no legal rationale to deem the response timely. In the alternative, the record was not developed regarding the separation from the relevant employer. The claimant in this case performed services for multiple separate legal entities that operated together. The employer has provided testimony and evidence regarding her separation from the last location she worked prior to the pandemic and not the named employer in this case. The employer in this case has alleged that the claimant was separated due to the pandemic, even though the employer did not report wages for the claimant during the quarter relevant to the pandemic. It would be inappropriate to issue a decision on chargeback in this case where the relevant separation has not been addressed. Remand and both parties invited.
The AT decision is not supportable. As with the other companion cases involving the employer's protest to the MPC should be considered timely. Regarding the merits of the chargeback issue, the employer's testimony and other evidence indicates that the claimant stopped working for the named company due to quitting while continued work was still available at this company's location. The employer's policy is that any employee can work at any company location, which means that they can go from one employer account to another at will. And this particular claimant actually worked at all of the company's locations as a floating manager. Of course, since she was a manager, she was in charge of her own schedules and assignments. A voluntary resignation for personal reason qualifies the employer for chargeback protection under section 204.022 of the Act. Accordingly, we should reverse the AT decision on the late protest issue, hold each protest timely, and protect the employer's account from chargeback.
Reverse the AT, timely response to the NMPC, no chargeback.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 291-9371, Commissioner Dimerson.
The AT decision is not supportable. The employer mistakenly reported in its initial timely response to the chargeback notice that the claimant had been transferred from the named employer's payroll to that of a company that bought the location where the claimant worked. Under normal circumstances, that kind of administrative work separation is chargeable. However, the employer's testimony indicates that the claimant failed to accept work with the new employer after the sale, and its commission appeal cites an applicable precedent that calls for an employer's account to be protected from chargeback under such circumstances. Accordingly, we should reverse the AT decision and protect the employer's account from chargeback. In the alternative, if my fellow commissioners are not ready to protect the employer's account at this point, we should hold a rehearing to obtain proof of a job offer from the new employer that the claimant rejected.
The AT decision should be affirmed. The separation from this employer resulted from the employer's sale of the business. Commission precedent holds that when an employee is transferred to a new company at the convenience of the employer, the separation from the first company is not under disqualifying circumstances, and the employer's account is subject to change. Affirm the AT chargeback.
Reverse the AT, no chargeback.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 3003351, Commissioner Dimerson.
The AT decision is not supportable. In similar cases this year, we have held that lack of proper information can be just as misleading to a party as improper information that is given to a party. In this case, the employer was not told on the notice of maximum potential chargeback that it could have dealt with its claim volume problem by simply sending TWC a spreadsheet of all the MPCs that it needed to protest. That is certainly an option that was available during the pandemic, and it should have been mentioned on the MPC, particularly when claimants, employers, and the Texas Workforce Commission were all overwhelmed by the volume of claims, appeals, and related proceedings. If the employer had the proper information, it could have responded to the chargeback notice on time. Regarding the chargeback issue, the employer gave testimony on the merits of the work separation, so that would be available for review. Accordingly, we should reverse the AT decision on the timeliness issue. The employer filed a timely response to the chargeback notice and then resubmit the case on the work separation and chargeback issues.
The AT should be affirmed. The employer uses a third-party representative to process their unemployment claims. The employer testified that they timely received the agency's notice. but they filed their response more than 2 months late because they did not have sufficient personnel to process their work. This circumstance was completely within the employer's control, and there are no good cause exceptions to the agency's timeliness rules. Affirm the AT, no timely response.
Reverse the AT, timely response to the NMPC, resubmit.
We will resubmit the case.
Case number 3014599, Commissioner Dimerson.
The AT decision is not supportable. As with other similar cases this year, we have held that lack of proper information can be just as misleading to a party as improper information that is given to a party. In this case, the employer was not told on the notice of maximum potential chargeback that it could have dealt with this claim volume problem by simply sending TWC a spreadsheet of all the NMPCs that it needed to protest. That's certainly an option that was available during the pandemic, and it should have been mentioned on the NMPC, particularly when claimants, employers, and TWC were all overwhelmed by the volume of claims, appeals, and related proceedings. If the employer had had the proper information, it could have responded to the chargeback notice on time. Regarding the chargeback issue, the employer gave testimony on the merits of the work separation, so that would be available for review. Accordingly, we should reverse the AT decision on the timeliness issue. The employer filed a timely response to the chargeback notice and then resubmit the case on the work separation and chargeback issues.
The decision is correct. The employer received the notice of maximum potential chargeback dated April 21st, 2020, in time to file a timely response on May 21st, 2020. The employer delayed appealing until September 16, 2020, because of an increase in mail volume they received due to the pandemic. The employer made no allegation that their response was delayed because of commission misinformation. Since there is no good cause exception to the timeliness rule, we should find the employer's response to the notice of maximum potential chargeback was late, and the employer's account is subject to chargeback as a result of this claim. Affirm the AT, late response to the maximum potential chargeback.
Reverse the AT, timely response to the NMPC, resubmit.
We will resubmit the case.
Case number 3022802, Commissioner Dimerson.
We should modify the appeal tribunal decision. First, I do not dispute the good cause finding. As to the job separation, the claimant was discharged for an absence while on a final warning. The claimant's daughter needed to use the claimant's car after hers was damaged in an accident. This was a simple transportation issue. The supervisor under oath denied having given the claimant permission to be off work. Careful review of the claimant's fact-finding statements and the testimony of the claimant's witness indicates that although the claimant may have told the employer he was planning to be absent, the claimant's supervisor neither agreed to the absence nor gave the claimant permission to be off work. Because the claimant was on a final warning for attendance and knew he was expected to be at work, he should have made alternate transportation arrangements. By being absent again after final warning, the claimant mismanaged his position of employment. We should modify the AT decision. The claimant had good cause for missing the AT1, misconduct, no chargeback, adequate employer response. The employer is a party of interest.
The decision is correct. The claimant missed the hearing because he did not receive the hearing packet until after the hearing. Therefore, he had good cause for missing the first hearing. Regarding the separation, the claimant was discharged for being absent on 10/7/21. On 10/6/21, the claimant asked the store director for permission to be off on 10/7/2021, and the store director agreed in front of another employee. While the store director did not remember giving the claimant permission to be absent on 10/7/21, the claimant's testimony that he had permission to be off work was corroborated by a coworker and should be given more weight than the store director's testimony. Since the claimant had permission to be absent on 10/7/2021, he did not commit misconduct connected with the work. Affirm the AT, good cause, no misconduct, chargeback, employer is a party of interest.
Modify the AT, claim established good cause for AT1, misconduct, no chargeback, adequate employer response. Employer is a party of interest.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 3057881, Commissioner Dimerson.
There is insufficient evidence on which to base a decision. The employer has alleged that it filed a timely response to the notice of maximum potential chargeback. Although it had no documentation proving that it had submitted a timely response, Its appeal to the commission specifically mentions that the employer can offer such evidence. Accordingly, we should hold a rehearing to obtain testimony and documentary evidence from the employer concerning an earlier timely response to the chargeback notice. I also agree that we should send a memo to investigate the potential issues of unreported earnings by the claimant during one or more claim filing periods.
The AT decision should be affirmed. The employer confirmed receipt of notice and testified they responded to it online. Commission records, however, do not contain any response from the employer, and the employer does not have any evidence confirming their alleged response. Commission rules require parties to corroborate testimony of a timely filing with either testimony of a disinterested party or physical evidence linked to an appeal in question. The employer provided neither. Affirm the AT late employer response to the notice chargeback.
Rehear.
We will rehear the case.
Case number 3106950, Chairman Daniel.
Because the commission communicated to the public on multiple occasions, including April 1st, 2020, that no employer would be charged based on separations caused by the pandemic, the employer reasonably relied upon that information and was misled into failing to appeal timely. The appeal should be deemed timely and the case should be resubmitted. Reverse the AT, timely employer appeal, resubmit on the NMPC and chargeback issues.
Commissioner Alvarez.
Huh?
It's your turn.
Just kidding. The decision is correct. The employer filed a late appeal to the charge liability decision. The employer's reason for doing so is they didn't believe they needed to respond. The document states they are being charged and that they disagreed. They need to appeal. Even if the employer was confused as to their need to respond to the notice of potential chargeback, that would not excuse failing to appeal the later determination. The employer has not stated an exemption to the timeliness rule. Affirm late employer appeal, late response to the notice of maximum potential chargeback, correct typographical errors.
Reluctantly, I must conclude that there is no way under current statute or TWC rule to hold the employer's late appeal timely. Although the employer's late response to the chargeback notice may be overlooked due to its confusion based on misleading information from TWC in April 2020 over whether a response was necessary, that same rationale cannot apply to a late appeal several months later. By that time, numerous clarifications had already been issued by TWC regarding the need to respond to all claim notices and determinations in a timely manner. None of the commission's statements regarding chargeback protection mentioned anything about parties not needing to file appeals. And the chargeback determination clearly indicated that an appeal would be necessary within 14 calendar days. While I greatly sympathize with the employer's situation, but we cannot ignore the plain meaning of our own statute and rule regarding timeliness of appeals. Reluctantly, we should affirm the AT decision. The employer's appeal from the appeal tribunal decision was late. However, since the AT decision included certain typographical errors, we should issue a modified decision noting the items that are being corrected.
Short form to so.
Yes, sir.
Chair, I'd also like to file a long form concurring opinion with the decision on this case.
Yes, sir.
Thank you.
Case number 3107018, Chairman Daniel.
Because the commission communicated to the public on multiple occasions, including April 1st, 2020, that no employer would be charged based on separations caused by the pandemic, the employer reasonably relied upon that information and was misled into failing to appeal timely. Reverse the AT, timely employer appeal, resubmit on the NMPC and chargeback issues.
The decision is correct. The employer filed a late appeal to the charge liability decision. The employer's reason for doing so is they didn't believe they needed to respond. The document states they are being charged and that if they disagreed, they need to appeal. Even if the employer was confused at their need to respond to the notice of potential chargeback, that would not excuse failing to appeal the later determination. The employer has not stated an exemption to the timeliness rules. Affirm late employer appeal, late response to the notice of maximum potential chargeback, correct typographical errors.
Just as with the previous case involving this employer, I reluctantly conclude that there is again no way under the law to hold the employer's late appeal timely. Although the employer's late response to the chargeback notice may be overlooked due to its confusion based on misleading information from TWC in April 2020 over whether a response was necessary. That same rationale cannot apply to a late appeal several months later. By that time, numerous clarifications had already been issued by TWC regarding the need to respond to all claim notices and determinations in a timely manner. None of the commission statements regarding chargeback protection mentioned anything about parties not needing to file appeals. And the chargeback determination clearly indicated that an appeal would be necessary within 14 calendar days. Again, I greatly sympathize with the employer situation, but we cannot ignore the plain meaning of our own statute and rule regarding timeliness of appeals. Reluctantly, we should affirm the AT decision. The employer's appeal from the appeal tribunal decision was late. However, since the AT decision included certain typographical errors, we should issue a modified decision noting the items that are being corrected.
Short form dissent.
Yes, sir.
Jerry, once again, I'd like to file a long form concurrent opinion with the decision on this case.
Yes, sir.
Thank you.
Case number 3144618, Commissioner Alvarez.
The claimant's appeal to the commission should be deemed timely. The claimant tried to fax her appeal on a late date to file a timely appeal, but the fax machine would not accept the transmission. Earlier, the claimant also tried to contact a TWC representative to ask questions, but could not get a response. Her late appeal was a result of inadequate agency resources, and her appeal to the commission should be deemed timely. Timely commission appeal and resubmit on the merits.
The claimant's commission appeal should be dismissed as late. The claimant filed her appeal beyond the applicable deadline to do so. There are no good cause exceptions to the timeliness rules. And as such, we should dismiss the claimant's commission appeal as late and leave the underlying decision in full force in effect. Misconduct, void the no chargeback ruling.
Late commission appeal, the AT decision remains in full force and effect.
Short form dissent.
Yes, sir. Commissioner Alvarez.
Case number 3151973, Commissioner Dimerson.
The appeal tribunal decision should be reversed. The claimant was discharged for poor performance. While the claimant denies wrongdoing, the employer stated that the claimant slept during meetings and did not do her part to bring new clients to the company. Since sleeping during meetings and not doing one's part to help the company are not indicators that someone is working to the best of their ability, the claimant's actions constituted misconduct connected with the work. We should therefore reverse the AT decision, misconduct, and correct the error in the AT decision. In the alternative, if my fellow commissioners do not agree, I would also support a vote to rehear this case. The employer submitted additional documentation to the commission that should be entered into the record. Specifically, the employer sent additional documents to the commission on April 7th, 2022, multiple times. These additional documents contain an image of a person who is purportedly the claimant with her eyes closed and her head rested on her hand. Although the employer submitted these documents multiple times, each submission should be entered into the record since it appears at least one of the submission does not have the image presented in full. The parties should be asked to authenticate the image and the identity of the person therein. Testimony as to what is happening in the image should also be taken. Rehear.
The AT decision is not supportable. The claimant was discharged by the employer. The employer both testified and provided documentation that the claimant had never performed up to the company's standards, even though she had worked for the employer for 7 years. Commission precedents holds that a claimant's inability to meet an employer's performance expectations is not considered misconduct connected with the work. Therefore, the employer's own evidence verifies that the separation is not disqualifying. Reverse AT, no misconduct.
Read here.
We will rehear the case.
Case number 3154566, Commissioner Dimerson.
We should affirm the appeal tribunal decision. The claimant violated the employer's policy when he completed a loan for a customer who was not in the claimant's presence. The claimant had received a final warning less than 2 months prior to the final incident. He should have known that any violation could have resulted in his discharge. The fact that the director of operations became aware of the claimant's actions did not diminish the claimant's policy violation while on a final warning. Thus, because the claimant was on a final warning for similar infractions, the claimant mismanaged his position of employment. We should affirm the AT decision, misconduct, no chargeback.
The decision is not supportable. The employer's policy prohibited providing a loan to an individual if they were not physically present to complete the paperwork. The claimant was discharged for completing the loan for a customer who was not in the claimant's presence. The claimant's director was in the room when the loan was being processed and assisted the customer's wife with both completing the paperwork. The director admitted to knowing that the loan was against the agency, against the policy at the time she was assisting the individual. The claimant, but not the director, was fired. In accordance with commission precedents, since the claimant, but not the director, was fired for the incident, the claimant was discharged for reasons other than misconduct. Reverse the AT, no misconduct, chargeback.
Because the claimant was terminated for a violation of an employer policy, but the supervisor that knowingly allowed the violation to occur was not terminated. The claimant was terminated for reasons other than misconduct connected with the work. Reverse the AT, no misconduct, chargeback.
Short form dissent.
Yes, sir. Commissioner Demerson.
Case number 315-5103, Commissioner Demerson.
The commission should grant a rehearing in this case. The employer requested a postponement due to one of its witnesses being unavailable. The employer repeats this statement in its appeal to the commission. Also contained in the appeal to the commission is the claimant's schedule and statements from two other witnesses that appear to have knowledge about the claimant's schedule. Between the employer's request for postponement due to one of its witnesses being unavailable and the highly relevant information regarding the job separation and the employer's appeal to the commission, we should grant a rehearing in this case to allow the employer to present its witness and to enter the claimant's schedule into the record. The employer should also be asked to produce the two witnesses mentioned in its appeal to the commission so that testimony can be taken regarding the knowledge of the claimant's schedule. Rehear.
I would agree to rehear.
Rehear.
Thank you. We will rehear this case.
Case number 317-8106, Commissioner Demerson.
There is insufficient evidence on which to base a decision. The employer has alleged that its third-party representative filed a timely response to the notice of maximum potential chargeback. Although it had no documentation satisfying the criteria under Rule 32 to prove that its representative had submitted a timely response, its appeal to the commission gives a good indication that such evidence exists. I note that no one has directly asked the employer's representative to provide proof at its disposal of whatever chargeback notice response it sent during the response period. Accordingly, we should hold a rehearing to obtain testimony and documentary evidence from the employer and its representative concerning an earlier timely response to the chargeback notice.
The decision is correct. The employer received the notice in advance of the deadline and forwarded it to the third-party UI administrator. Although the employer alleges the third-party administrator sent a response before the deadline, they have not provided any evidence of that response. Affirm the AT, late response to notice of maximum potential chargeback.
Rehear.
We will rehear the case. And that was the last UI case pulled for additional discussion on docket 31. You should have received the UI short form dissent list for docket 31.
I move we accept staff recommendations on the remaining UI cases on docket 31.
I second the motion except for those cases of which I'm dissenting as reflected on UI short form dissent list for docket 31.
I concur with the chairman's motion, except for the cases on which I'm dissenting as reflected in the UI short form dissent list for docket 31.
Motion passes with the exceptions noted.
Thank you, sir.
Well, thank you. Let's take a short break. We're back. This is agenda item 8, estimated UI trust fund balance report.
Morning, Chairman, Commissioners. For the record, Chris Nelson, Chief Financial Officer. This morning, you have the document, which is the unemployment insurance trust fund projection. And this document is meant to serve kind of several purposes. One is to project the unemployment insurance trust fund balance, more specifically on the upcoming October 1st date. And that date's important because, as you recall, that's when the floor test is done to determine if the trust fund is above the floor, which could impact a possible deficit tax. And it also looks to see if we're above the floor and a possible transfer from the ETIA fund into the skills appropriation, which I'll walk through at the very end. So it's been a while since we've gone through this. I'll kind of walk through the timeline of it. So on October 1st, at the very top right corner, we were of 2021, we were 5.8 billion in the hole as far as the trust fund is concerned. And everything after that is basically a projection all the way up until this coming September 30th. So we're projecting to receive 2.5 billion of revenue from employer remittances. You've got some depository interest and possible transfers from other states to make up another 23 million. Line 1.06, you see the 6.9 billion we received from SB 8, which got added to the trust fund. Some of that 5.8 billion immediately went to repay the Title 12 loans. We've projected to collect another 104.5, or the 104.5 million was what we transferred last year, that since we were below the floor, it transferred, the statute requires if you're below the floor to transfer any available balance from ETIA into the trust fund. So that 104 is what we transferred coming out of last year. We're projecting to pay just under 1.7 billion through the September 30th, which leaves a projected balance of 2.157 billion on October 1. And as you can see on 2.01, I believe it is, we're projecting the floor to be 1.284 billion, which is puts the balance at 873 million above the projected floor. So at the bottom, it labels out schedules out the ETIA fund. So we started with the $105 million balance. We're projecting to collect another 132 billion. We removed the collection fee since we can't charge the UI grant for collecting the ETIA tax. We have to deduct any collection cost, which is mainly staff cost. And then you see the 104.5 million reduction that we transferred earlier up in 1.07, which leaves an estimated balance of the ETI fund at 132.5 million. And since we're projecting to be above the floor, about 19, just under 20 million of that balance will go, and it will basically replace the general revenue skills appropriation in 2023. It doesn't add to the skills appropriation. It just replaces the general revenue with the ETIA fund. And so that in my next report, probably in 3.04, you'll see a negative $20 million reducing that ETIA balance. So that's all the comments I have. I'd be happy to answer any questions.
Any comments or questions?
None here, Chairman.
I'd just like to applaud our Texas employers for the resiliency. This is a good report, and it's always good to be above the floor in that particular case, and it's going to allow us to fund trainings like programs like the Skills Development Fund that's going to, again, aid our employees in the state as well.
All right, thank you, sir.
Thank you.
Agenda item 9, WIO statewide reserve distribution has been postponed to a future meeting. I'm showing that staff has nothing to present under items 10 through 12. Is there a legislative report today? I don't see anybody here doing that. Is there an executive director's report today?
No, sir, other than to say that several staff members will be in Arlington meeting with board members, local board members and executive directors at the end of this week. So for EDC and TOB.
Thank you. Is there any other order of business come before the commission?
Chairman, if I may recognize Christy Cavanis, Julio from the communications team and that group, Brady Akers from my office, and the folks that served on panels at the Grace Conference. I thought the conference did well, and very excited on the responses that we received as a result of putting that first time conference together. So I just wanted to recognize those individuals.
Two quick things. Also, Commissioner Alvarez, commend the efforts in the team on the Grace Conference in San Antonio. Well attended, good event, very emotional, well-driven event. And again, providing Texas employers with another option for this talented pipeline. And then secondly, just thank you, gentlemen, and the entire group, your team, for the Texas Interns Unite initiative we held last Friday. A very successful conference with the Higher Education Coordinating Board. So continue to appreciate Commissioner Keller's support of those efforts as well. And then Julia and her team, I keep bumping into them at these conferences with our TCs and the like. And so they're doing a phenomenal job of making all those things happen. And that circles back to the leadership that you're providing, Ed. So thank you.
Chairman, if I also may congratulate you on the intern event that you had last week, and your staff did an amazing job, and to have us three there to participate was really cool, and to have Secretary of State there, Scott, as well. Another person I failed to recognize on my comments regarding the conference was the Office of Employer Initiative staff, and of course, Reba Bacon and all her work for serving as the Master of Ceremonies.
All right, good stuff going on. Is there a motion to adjourn?
Chairman, I move that we adjourn.
I second that motion.
It's been moved and seconded to adjourn. We're adjourned.